Chair lays out the following resolutions. Secretary will read the resolutions.
SR 413 by Miles, SR 415 by Blanco.
Members, this is a voice vote. All in favor say aye. All opposed say no. Ayes have it. All 8 of you. 2, 4, 6, 8, 11, 12. Excuse me. 13. Senator Swertner, you're recognized. Suspend the regular order of business on committee substitute for Senate Bill 3030.
Thank you, Mr. President. Members, Mr. President, I move to suspend the Senate's regular order of business to take up and consider at this time the committee substitute to Senate Bill 30. Members, in 2003, this legislature passed House Bill 4, the Tort Reform Bill, which included a one-sentence statute governing how medical costs are presented in civil lawsuits. This law provides that recovery of healthcare expenses in tort cases is limited to the amount actually paid or incurred by the plaintiff, commonly known as the paid or incurred statute. Over the past decades, certain plaintiff attorneys have expanded efforts to present inflated medical charges to enhance incurred medical bills beyond what is reasonable by colluding with affiliated healthcare providers who overdiagnose, overbill, and overtreat, what I term the medical mill. Further, these enterprising attorneys often manipulate the discovery process that distorts the balanced collection of evidence during the trial. In addition, in further complicating tort cases, jury instructions have ambiguous provisions that allow plaintiff attorneys to easily prejudice a jury's calculations, often leading to exorbitant compensatory awards. These factors have led to a fundamental unfairness in civil trials over torts and created an unstable legal environment that is driving up costs for Texas families and businesses. This bill, Senate Bill 30, addresses these concerns by first limiting the admissibility of artificially inflated incurred medical costs. Second, by clarifying non-economic damages. And by third, standardizing trial protocols and jury instructions statewide to allow for uniform application of the law. Members, Senate Bill 30 will restore fairness and transparency in civil trials, stabilize the currently volatile legal environment, and return reasonable insurability to Texas families and businesses. Most importantly, it maintains a just and fair tort system that allows for the proper redress of individuals wronged. As I've already distributed, there will be several amendments that further clarify the definitions of non-economic damages, as well as maintain the rules of evidence as a standard for evidence admissibility in trial. With that, Mr. President, I move suspension.
A few people would like to chat with you. Senator Huffman, what purpose?
Question the author of the legislation.
Do you yield?
I yield. Thank you, Senator.
Thank you. Senator Swartner, just in a couple of questions about kind of overview of your legislation. We talk a lot about the criminal justice system, and I think we've had several bills in here today that we were talking about various aspects, Senator Flores and so forth, about the criminal justice system. But sometimes we forget that there's also a civil justice system, correct?
Absolutely. Yeah. For various types of wrongs and torts, whether they're intentional or negligent or from defective products, for instance.
And would you agree with me that just like in the criminal justice system, where we work very hard to protect the rights of the defendant, the accused, but also work very hard to protect the victim and make sure that there's justice, that there's two sides to the system that both have extremely important rights, and that we as legislatures have to work very hard to preserve those rights on both sides. Would you agree with me on that?
I agree with you completely. The system has to be fair and consistent and represent the upholding of the rights of both those, in this case, the defendant and the plaintiff, to where the finders of fact, the jury, can have a outcome that is based on the evidence and is appropriate for the alleged act.
So, of course, we're extremely concerned about the rights and the repercussions of the system to those who have been harmed, especially by egregious negligence or other forms of torts that have inflicted great harm. That's one side of the coin, but the other side is also the businesses, the small businesses, those who are drawn into a system that literally can crush them economically and create economic hardship for others Texans, whether it be through increased insurance premiums or other results of abusive lawsuits. Is that fair that there's two sides to look at?
Absolutely. It's obviously the concerns of those that have been wronged in a case to seek just and fair compensation, but also the societal concern about a legal system that is transparent, that allows for the introduction of all evidence, so that those individuals of our peers, the jury of our peers, can make an informed decision regarding that trial.
And you and I, we've had personal discussions about this bill, and we both, and I'll say this publicly, we both have had great concerns about Texans or others that have been in the state who have been egregiously harmed and disfigured and hurt by negligence. And part of this bill is to make sure that they have just compensation. Is that a fair statement?
It is. It is extremely important that the system we have here in Texas maintains a just and fair system for all parties, those injured as well as the defendants, regarding the introduction of evidence and the ultimate conclusion by the jury regarding the culpability and the award subsequently awarded.
Do you feel like this legislation will bring more trust and certainty to the civil justice system, in the sense that it brings both a little bit of predictability when it comes to the admissibility of evidence and as it comes to the jury charges, and just the backbone of how the court system works, how the trial works? Do you feel like this bill will bring that type of trust and certainty to the trials of these types of cases?
I think the uniform application of laws during a trial will certainly enhance the tort system here in Texas.
Do you still equally feel that this bill would allow those who have been horribly harmed to receive a just and fair compensation when they have been greatly harmed in whatever shape or form that may be?
100%. There are no limits on the awards that a jury can impose at the end of a case. regarding non-economic damages or economic damages. And of course, there are punitive damages on top of that if there's a unanimous verdict in the case of a civil tort case.
All right. Thank you for your work on this, Senator Schwertner. And you've listened to many stakeholders. You've listened to many senators. A lot of people had different viewpoints, but I think we're all trying to achieve a fair, balanced, and predictable civil justice system. So thank you for your work.
Thank you, Senator.
Thank you.
Senator Zaffirini, what purpose?
Questions of the author of the bill?
Do you yield?
I yield, yes.
Thank you. Senator Schwertner, we had approximately 40 persons register against the bill. And I asked you in committee how you would listen to them and how you would work with them. And I believe later you said that there was a compromise. Could you explain how a compromise was reached with these people? I'm talking about the 40 people who testified against the bill.
Well, I certainly listened to all the testimony, the 7 hours of testimony, and continued to work and listen to members on this floor, as well as members across the Capitol Rotunda, and stakeholders and their associations. There were aspects of the bill as introduced that put in various provisions that were fairly unreceived, called remititure, for instance, and thresholds for various awarding of non-economic damages. Those were extracted from this bill. Other aspects of the bill regarding how various definitions were refined are also in this bill as a committee substitute, but also with the floor amendment. So I think it is a very holistic approach that I have tried to undertake in fashioning a bill that reforms our civil justice system here in Texas, that again addresses the concerns brought about by runaway medical costs leading to very large verdicts, and the rights of those that have been injured, as well as the rights of the defendants when it comes to tort cases.
Thank you. You also heard from some of the victims of abuse, especially sexual abuse, and some of their families. And some of the committee members, including Senators Paxton, Senators Betancourt, asked some very pertinent questions about victims of sexual abuse and how they would be treated. What changes did you make in the committee substitute or will be made by virtue of floor amendment to address those concerns, specifically about victims of sexual abuse?
Yes. When it comes to obviously tragic and terrible occurrences and wrongs like that, I wanted to make it explicitly clear in the non-economic definition section that sexual abuse was clearly recognized under the physical pain and suffering and mental and emotional pain and anguish sections. And so those have been refined, and you'll see that in the amendment, which has already been distributed, of course, to the members on this floor.
Thank you so much. On pages 7, lines 19 to 21, you address the issue of capping medical damages at Medicare rates. Given that providers often refuse to accept Medicare because of its below-market reimbursement rates, how does capping medical damages at 300% of the Medicare fee schedule ensure that plaintiffs can recover the actual reasonable cost of care provided by non-Medicare providers in the private market?
Well, this bill does not, if a bill has already been paid, that certainly is admissible as a economic expense in tort cases. Regarding the 300% of Medicare plus a cost of living adjustment, I think it is completely appropriate to address the inflated medical bills that are occurring in our civil justice system currently. Other states have done it. For instance, Florida capped it at 120% of Medicare. 300% of Medicare is very much a reasonable rate to set as the upper threshold for which a medical bill will be recognized in a personal injury case. Obviously, there are many different providers in Texas. I'm a provider. I know that rate is an extremely high rate, actually, relative to insurance rates, for instance, which are often Medicare plus a small percentage, 120%, 150%. So 300% of Medicare plus a cost of living allowance, an adjustment based upon inflation, is a reasonable and fair compensation methodology for those providers that are providing care to those that have been injured in a tort and receive compensation that is commensurate with them having to wait to receive that reimbursement till the conclusion of a trial and the awarding of a award, as well as the uncertainty associated with whether or not there will be an actual verdict there in the trial that would allow for an award.
Thank you. And at the committee hearing, both times that we heard this bill, first the bill and the second the committee substitute, you were very clear in saying that you were not talking about a 300% rate, but up to 300% reimbursement rate. Is that correct?
That is correct, yes.
It's not 300% across the board.
It is up to, if the bill is less than that, that's up to that provider to set that rate up to 300%. It's just that the court system would not only recognize up to 300%.
Thank you. And continuing on page 7, lines 23 to 31, doesn't using Medicare as a universal benchmark for damages conflict with the Texas Constitution's prohibition against arbitrary caps on economic damages, especially if the plaintiff never accessed care under that system?
Yes, I appreciate that question. That issue has been raised. There's case law, Texas Supreme Court case law, that very clearly substantiates that it is allowed. The 2021 K&L Auto Crushers case, as well as the 2018 Texas Supreme Court case of Fort Worth Transportation Authority versus Rodriguez, both affirm that and uphold that the upper threshold limitation placed in this bill is constitutional under Article 3.
Thank you. How does this bill accommodate rapidly rising healthcare inflation when future damages are locked to Medicare rates on the date of trial, which may significantly understate the true cost of long-term care?
Well, it's as of May 1st, 2025 in the bill, as far as the Medicare fee schedule, adjusted for inflation. That's one of the amendments. And so the adjustment for inflation was the compromise regarding time and elevation of healthcare costs over time.
Thank you. Also on page 7, you address the issue of admissibility and clean claim billing. Doesn't requiring a clean claim format meant for insurance reimbursement purposes for admissibility of medical bills in court create procedural traps to exclude evidence?
No, I think it makes it standardized and uniform so that everybody can understand what is being billed. We have to do that as a provider when we submit charges to a health insurance, and I think it is quite reasonable that plaintiff attorney firms and the affiliated providers of those plaintiff attorney firms submit in the same manner.
Thank you. Earlier in the bill on page 3, lines 25 to 39, you address the issue of restricting non-economic damages, specifically for mental anguish and pain. Doesn't consolidating distinct harms such as disfigurement, physical impairment, and loss of consortium into narrow definitions thwart the juror's ability to evaluate the full scope of a plaintiff's injury?
No, not at all. I believe the current methodology leads to a irregularity and disparity of how awards are conducted regarding non-economic damages, and further clarifying them by having physical pain and suffering and mental and emotional pain and anguish as two big categories with definitions and further clarification underneath those two large categories. And then instruction to the jury allows for a uniform application of law when it comes to personal injury and death cases.
Thank you. In that same section, what is the justification for requiring proof of substantial disruption in daily routine when evaluating mental anguish?
Yes, that's also changed in one of the amendments. It's going to change to instead of saying daily routine, to life. So it's a broader category that is more of an allowance. But I would actually say to you that the daily routine terminology is actually from a Supreme Court case that the Parkway County versus Woodruff case that clarified the emotional pain aspect and awarding of non-economic damages having to affect a daily routine. So there was concern about that terminology, and so I changed it. And I think instead of saying, instead of saying disruption in a person's daily routine, it will now say disruption in a person's life. So it's actually more lenient and expansive relative to the Supreme Court's ruling when it comes to mental pain and anguish.
Thank you. How would that standard impact survivors of sexual assault who may continue to function outwardly, but who have deep mental scars?
Well, I think it allows for full redress of the damage that has been caused to that individual. It in no way limits just and fair compensation for that individual.
Thank you so much. On page 2, lines 46 to 69, and page 3, line 1, you address the issue of discovery and trial testimony limits. Doesn't limiting a plaintiff's ability to conduct discovery or compel trial testimony from healthcare providers based solely on the filing of an affidavit preclude transparency and the right to challenge the opposing party's evidence?
Well, the affidavit came about because we didn't want to be, going back years and even decades ago, because we didn't want to be having to pull in all sorts of providers into a trial. And so the affidavit, if a provider signs an affidavit that their charges are 300% of Medicare or less as adjusted by inflation, then they would not be pulled into the trial at all. So it maintains efficiency in the court system.
Thank you. On page 8, lines 6 to 21, you address the issue of burden shifting and fairness in discovery. Aren't you concerned that requiring disclosure of attorney referral patterns, financial relationships with providers, an anonymized patient list disproportionately burden low-income plaintiffs, particularly those who rely on letters of protection or who lack access to traditional insurance-based care?
No, I think that evidence is absolutely critical that the finders of fact, the jury, obtain. I think these kickback arrangements and inflated healthcare bills and statements and letters of protection and affiliated providers, that should be known. That is not something that should be hidden. That is causing increased and inflated healthcare medical bills that subsequently lead to the awarding of awards that at times are much larger than is appropriate relative to the tort, to the injury.
Thank you so much. On page 7, lines 32 to 37, how do you justify the evidentiary rule that awards $0 for service if it lacks an industry billing code, such as home modifications or certain mental health therapies, regardless of medical necessity or harm suffered?
Well, home modifications don't have a medical code. They're not a medical
Right.
intervention. But psychological and counseling do have codes and would be actually reimbursed if submitted.
Thank you so much. Overall, based on the public policy and equity addressed in this bill, are you aware of any impact analysis that has estimated how many Texans, particularly low-income, uninsured, or rural residents, would be prevented from recovering their actual out-of-pocket medical expenses or non-economic damages under this bill?
Senator, I think the compensation for the medical bills is highly recognized in this piece of legislation, and that there would not be any medical bills that would not be that are appropriate medical bills that would not be actually paid for.
Thank you. And frankly, Senator, if you're concerned about inflated medical bills, why not improve safeguards against fraud or against abuse, rather than impose broad categorical restrictions that also penalize good faith plaintiffs with legitimate injuries?
Well, we have lots of various provisions regarding waste, fraud, and abuse in healthcare laws. This bill is a bill regarding the Civil Practices and Remedies Code, Section 18 and Section 41, regarding the admissibility of healthcare costs, medical bills, and then also the protocols and standardization for uniform application of law during a personal injury lawsuit, and the subsequent jury instructions regarding non-economic damages.
Thank you, Senator, and thank you for answering the questions not only at our very lengthy committee hearings, both of them, but also today, and especially for giving us the information in advance so that we could look at it and prepare our questions accordingly.
Thank you, Dean.
Thank you. Thank you, Mr. President.
Senator Paxton, what purpose?
To ask the author a few questions.
Do you yield?
I yield.
Thank you, Mr. President. Thank you, Senator Schwertner, for engaging in the dialogue with the members of the committee, with the members of this body. I recall very distinctly in the first hearing of the original bill that you said very clearly to all of us that you were wanting to get feedback from us as we listened to the testimony. And I know that you did listen to the witnesses very carefully. And I saw substantial changes between the original bill and the committee substitute. And I appreciate you circulating the amendments so that we could take a look at that and have some confidence about what this is going to look like in the end.
Thank you, Senator. Your input and the other members on the floor was vital in fashioning a bill that I think is appropriate for the state.
Some of these things have been touched on by Senator Zaffirini, but just for clarity, if you wouldn't mind just answering just a few questions about the differences between the committee substitute, which many people who are interested in the bill are familiar with, and the amendment, which is coming.
Right.
We talked a little bit about the 300% of Medicare, and one of the concerns was for individuals who might need long-term treatment, and so maybe something that would go on for 10 or 20 years, depending on their condition. And of course, during that time, they also would be aging, and so those are all things that would impact the cost of that care. And in the committee substitute, I believe that was indexed to today's Medicare rates, but that is not the case in the amendment. Is that correct?
It is indexed to inflation and indexed to today's Medicare rate as of May 1st, 2025. You have to pick a base to index something to. Medicare, the fee schedules of Medicare change on a yearly basis. There's a very complex process in which various providers go before Medicare and talk about how much time and difficulty it is to do a certain type of intervention. And the fee is changed on a yearly basis. Usually it's decreased. So sometimes basing it on something in the past is better because the fee schedules in the past were significantly higher for certain types of procedures than they are actually today. But you have to make a choice, and this bill sets the upper threshold for which a court would recognize medical bills at 300% of Medicare as of May 1st, 2025, indexed to inflation as measured by the CPI.
Well, thank you. I think that's significant to a lot of the folks that I've been talking with, knowing very clearly that it is indexed to inflation. Because that's important to a lot of folks.
And thank you, Senator. And your point about a person severely injured with long-term health care costs, there's an awarding of compensatory damages in a personal injury case, a negligent case, for instance, or intentional tort. You have the economic and then you have the non-economic. And the economic damages can be quite significant. And of course, those are figured and calculated. There's obviously a guess aspect to it, right? You really don't know what someone's going to need if they have they're an amputee or paralyzed, for instance, 20 years from now or 40 years from now. But you have to make a decision as a court, as a jury, regarding economic damages and then non-economic damages. And the non-economic damages are classified in this bill as physical pain and suffering and mental and emotional pain and anguish, with the provisions, as people have looked at and studied already, regarding how those are further defined.
Well, thank you. Moving on to the things we talked about with matters that involve victims of sexual assault, victims of child sexual abuse. Specifically, there's sort of a saying among the folks that work with these survivors that not all wounds are visible. And we've talked about this in the committee. There is the language in the committee sub that requires an injury to be observable. And I believe that you made some changes with regard to that in the amendment. Could you address that?
Yes, under the physical pain and suffering portion of the definition of non-economic damages, there's been the addition of subsection 2, which very explicitly details that in cases of sexual assault or abuse is corroborated by medical evidence or a prior consistent statement. That is the justification for physical pain and suffering. So it highlights that, actually, and I think it is an important addition to the definition of physical pain and suffering portion of non-economic damages, and very clearly allows for victims of sexual abuse to be recognized by this definition.
And it also includes the recognition that sometimes the abuse or assault occurred some time ago, and there may not be existing medical evidence, but there are other types of evidence that are allowable in those kinds of cases that prove up the claim.
That's right. And again, very clearly, by medical evidence, if it's a recent, obviously, event, and or, not an and, but or, a prior consistent statement.
Thank you. And of course, the wounds that are not visible are nowhere more prominent than when we talk about mental and emotional pain and anguish, especially for these kinds of survivors. In the committee substitute, there was the language that required the suffering to cause a substantial disruption in a person's daily routine. And I wondered if you would mind reiterating the replacement for that language.
Certainly. I will first tell you that that language came about because it is case law from a Supreme Court case regarding a tort and the mental and emotional aspect of non-economic damages. And the Supreme Court talked about how it needed to have a daily, affect a daily routine. That was, again, the Parkway versus Woodruff case, 1995. It was not, there was a lot of uneasiness regarding that particular provision. And so the amendment on the floor that will be addressing that will be changing daily routine to life. And just to read it very clearly for the entire body and those listening, mental or emotional pain or anguish means grievous or debilitating angst, distress, torment, or emotional suffering or turmoil that causes a substantial disruption in a person's life. The term includes mental or emotional pain or anguish arising from loss of consorption, loss of companionship in society, loss of enjoyment of life, disfigurement, and physical impairment.
Thank you. I think that's so important for survivors of any kind of trauma, particularly sexual assault or child sexual abuse, but individuals who have experienced that or know and love people who have experienced that know very well that sometimes it isn't apparent that there is any change in a person's daily routine. They are going through the motions almost mechanically, but inside they're really struggling and they are experiencing tremendous mental anguish. And so I think it's a great example of not all wounds being visible, but I appreciate the change in the language. And also to that point, I wanted to point out that you had approached me about, given that many of these individuals, part of the recovery that they go through involves seeing a therapist or a counselor. And I believe that you added some language to that effect also in the amendment in the provider section.
That's right. In the provider section, there is a list that is not an exclusive list, but I thought it was pretty well delineated, and I thought it was extremely important that we added licensed professional counselors and psychologists. Psychiatrists are already MD or DOs, so they're already part of the physician part of that list, and so LPCs and psychologists were added.
Yes. Well, thank you, Senator Schwertner. I appreciate your attention to the concerns of the body, and I think it's much better for all of the input. But of course, we can give input all day, and if you are not willing to receive it, it doesn't really go anywhere. And we appreciate, I think I can speak for many of us, we appreciate that you receive the input so willingly. Thank you.
Thank you, Senator.
Senator Menendez, what purpose?
Thank you, Mr. President. Questions of the author?
Do you yield?
I yield.
Thank you, Mr. President. Thank you, Senator Schwertner. I was going over the types of non-economic damages your bill eliminates, and does it eliminate any non-economic damages? I believe you mentioned it did not.
It does not. It clarifies non-economic damages and really, I wouldn't say condenses, but redefines non-economic damages. As you know, Senator, non-economic damages do have a current definition in statute in Chapter 41 under Section 41.001, line 12, and the provisions, I won't read them all and compare them line by line, but the totality of the two are very similar. But I thought it was important that they be clarified in a more cohesive manner, so that when a jury is instructed and sent back regarding the delineation of an award, the award of one trial and judge might be to tell you to look at 10 different things. In this case, the instructions at the very end of the bill, you might see very clearly the last section, section 41.152,
on page
the jury
9.
Instructions.
Yes, on page 9.
Delineates what they should be contemplating when awarding non-economic damages, with the first four being applicable to almost all cases, the fifth and sixth really just to defamation cases. So
I'm glad you changed or refocused us on the pattern jury charge when asking the jury. Is the answers on page 9, lines 1 through 12. So the question that I have is, if there is evidence that the plaintiff has been horribly burned, when would a jury be asked about damages awarded for disfigurement? Why is disfigurement not included?
Disfigurement is included, Senator, under mental and emotional pain and anguish definition.
So the jury would have to say that if the...
And actually it would be under physical pain and suffering as well.
Okay. All right. So let's say we're going to ask them to include that under pain, suffering, and possibly mental and emotional.
It specifically says disfigurement under mental and emotional pain and anguish portion of the bill under subchapter A.
On page 9?
I'm looking at it's page 6, but I can look at it on the...
Yeah, I was looking at the jury instructions. That's why I was...
Oh, no, the jury instruction. No, what you have to do, Senator, is the jury instruction is physical pain and suffering, past and present, future pain and suffering, and past and present, or past and future mental and emotional pain or anguish.
Right.
Those have specific definitions in law currently, as well as under this bill. So you have to then refer back to the definitions of each one, which will be part of the jury instruction, of course, regarding the aspects of past and present physical pain and suffering, and past and future mental and emotional pain and anguish.
So would the same be true for impairment? If there was evidence that the plaintiff was seriously impaired, would that be the same, or is that?
Yes, that's also under the definition of mental and emotional pain and anguish.
And what page would I find that in your bill?
Senator, let me find that for you.
Sorry about that. I was just looking at the instructions for the jury.
It's page 3, Senator, and I'll find the line number. Yes, page 3, line 330, 30 and 31.
Okay, here we go. Mental and emotional pain, loss of disfigurement, physical impairment. Very good.
And then the physical pain and suffering is under line 32 of the bill, but it will again be adjusted with the amendments that I will be authoring and brought to the floor and have been discussing with Senator Zaffarini and Senator Paxton, and have been distributed already to the offices.
So there's been a question. I'm sure that in the deliberation and the working on this bill with all the parties that you've worked on, that you've been made aware of the Texas Supreme Court in Harris versus Smith. I think it was a case that was decided in 2002, where it held that it was harmful error to use jury questions that include elements of damages, for which there's no evidence with the elements of damages that did have evidentiary support. Are you familiar with that case, Senator Shortner?
Senator, I'm not familiar with that case.
So the reason I bring it up is because it seems to me like the bill may do exactly what the Supreme Court said we shouldn't do, because one of the questions that comes up is, how would a trial court or an appellate court going to review the jury's decision when the basis of this decision is not clear, because the types of damages are no longer asked about separately in light of the Harris versus Smith decision? Have you contemplated that?
Well, under the bill, the court shall provide the jury definitions and instructions required by this chapter and other law, and ask the jury, if appropriate, determine the amount of money that will fairly and reasonably compensate the claimant for, and again, it lists past and future physical pain and suffering, and past and future mental and emotional pain or anguish. Right now, Senator, one of the problems that we are addressing in this bill is the variability of jury instructions regarding how they tell a jury to delineate non-economic damages. Sometimes it is just the whole list and, put a number by whatever, or sometimes it's a checkbox of a 4x4 or an 8x8. So there's not uniform application of how the instructions are given to a jury.
Right.
And there's easily swaying of juries by plaintiff attorneys doing their job, trying to obtain an award, and the conflating of the awards regarding various categories. Sure. And so that's one thing this bill straightens out, is jury instruction and the definitions of non-economic damages, to where there's more uniform and consistent application during personal injury lawsuits.
Have you ever served on a jury, Senator?
I've not served on a jury, Senator.
Have you ever sat on a panel where the judges ask you, or the plaintiffs and the defendants ask questions of the potential jurors? Have you ever been?
I've witnessed that. I've not sat on one of those panels.
So many years ago, before I got involved in politics, I was a young, right out of college, and I got asked to jury duty. And what I was surprised by many of the questions that were presented to the jurors in terms of educational attainment, positions, this and that and the other. And I was disappointed by who was struck from the jury panel. And what concerns me, one of the things that concerns me is that if in your jury instructions they just say to the jurors, past physical pain and suffering, future physical pain and suffering, all of these terms, I'm concerned, are they going to be handed the definitions that also say that will include, or are they just being told those points there and asked to assume what the definitions are?
Senator, it's clear in the last part of the bill that the court shall provide the jury definitions and instructions required by this chapter. Right now, they're not receiving that in a way that is consistent across the state of Texas. Each district court, I'm advised, does things slightly different when it comes to jury instructions and personal injury cases. I think that uniform application is necessary for the proper administration of justice in the state.
I don't disagree with that. I worry that we could be doing things that would potentially, it seems like you're trying to provide more clear instructions and standardized instructions, but I just want to make sure that we don't make it more difficult for people to get justice. And I appreciate you taking my questions.
Thank you, Senator.
Senator Hagenbu, what purpose?
Next question, the author.
Do you yield?
I yield.
Thank you, Mr. President. Senator Swartner, thank you for all the work on this. You put a lot of effort into the bill and the amendments and things, I know. As a senator, but also as a businessman, I want to make sure I understand this, so I want to ask you a couple of questions. I think what you're trying to do in this bill is strike a balance in these trials, personal injury and other type trials, where there's a balance between the plaintiffs and the defendants where currently there's a real imbalance. Is that accurate?
I want a just and fair application of the law that allows for uniform application of the law during the trial and a compensatory award awarded for those that have been harmed that is commensurate with their injury when deciding economic and non-economic damages or even punitive damages. So I think we need to have a reevaluation of the current system, because what we have now under the paid and incurred system and under the definitions of non-economic damages allows for a system that at times can be egregious in its methodology of how a claimant is awarded an award for a wrong.
Thank you. And then beyond that, at a more of a broad macroeconomic level, I think you're trying to strike a balance here as well. It's important to get an economic balance, I believe, here. Currently, Texas businesses are experiencing exorbitant insurance cost increases. The premiums are going way up. I see that in every businessman I talk to. But particularly, take my industry, for example, the trucking industry, which, by the way, is so often disparaged by trial lawyers, make a lot of money off of these cases. But that industry, 80% of everything you get comes on one of those trucks. And 90% of trucking companies are 10 drivers or less. So you're talking about small businessmen would have to carry large liability insurance policies. 2 years ago, I went to talk to my agent. I'm with one of the insurance companies. You're hard to get. You got to be a little safe trucking company to be even with this insurance company. And I said, hey, we got even safer this year. I hope we can at least keep our premiums for liability insurance flat. He said, nope, you're going to go up 35%, and you're lucky because you are a safe trucking company. It ended up, $1 million a year increase, my liability insurance. And I said, why? He said, it's because of these huge verdicts they're paying across the industry. We got to cover them as a whole. So huge increases like that. And we, we're the primary delivery source for 1,500 grocery stores across the country. We kept going during COVID and kept the food supply chain going. We're doing all right, but most trucking companies, for example, are having a hard time staying in business. And a lot is because of how much they're paying in these liability insurance premiums. Now, I'm a trucking company that delivers food, so I got to pass that along to the grocery companies. That gets to pass along to the consumers. We talk about affordability in many cases. Many of our bills are about that. This might be the most important one to me for affordability for Texans because it's driving up your food prices, like I just talked about. But also, we're all seeing our auto insurance prices liability rates going up by 200, 300%. So it's a big impact on Texas businesses. It's a big impact on Texans, citizens. And then you got on the other side of it, I'm sorry, but you have trial lawyers who have enough money to buy jets and be on a Super Bowl commercial. And you got big companies like BlackRock, who are the Wall Street companies. They're so lucrative now that they're making investments in these cases. Something's wrong. There's an imbalance someplace in our system when consumers and small businesses are having this kind of trouble with liability insurance costs. in the auto insurance costs, yet these people over here are making a fortune. So is this bill you think, going to help rectify that and balance that to some degree?
Thank you, Senator. I know you have firsthand knowledge. The average Texas family, average Texan, they buy their auto insurance and they see rates go up. They buy homeowners insurance and they see rates go up. And there's a whole host of reasons why that happens. But a reason a lot of people don't realize is increased liability, not just the magnitude, but the frequency of claims and lawsuits. And so there is an imbalance, a problem now. We have in the state of Texas, since 2016, 104 awards that were over $10 million. I think there were 20 that were over $100 million. One was actually over $8.7 billion. So, there's a concern that people in totality are bringing to us regarding economic costs, insurance costs, both from a business standpoint, but from a personal standpoint, that does point to some of the things you mentioned regarding the TV ads that are running and jets and come sue somebody and win an award. That points, in my opinion, when you see something like that, as something that needs to be fixed. And this is the bill that I think still maintains a system that allows for just and fair compensation of those that have had tragic and terrible occurrences happen in their life, but at the same time allows for the proper evidence to be submitted and evaluated in a trial and then adjudicated by a group of our peers.
Thank you. I agree with you. I believe it does what you said, which is if you're injured, still you're going to be able to be compensated fairly, and you should be if there's someone negligently injures you. But also to try to reset some of this imbalance that's pretty obvious from some things I was talking about. Well, I thank you for the effort you put into it. Really appreciate it. I think it's a great bill. And thank you, Mr. President.
Thank you, Senator.
Senator Colcourse, what purpose?
To ask questions of the author.
Do you yield?
I yield.
Thank you, Mr. President. Senator Schwertner, thank you for this work on this. I heard you say you've spent, just in the last couple of weeks, 100 hours on it, working to perfect the bill.
It's been a lot. This is a weighty substance. It affects all Texans. No one knows when they're going to be injured. No one knows when they're going to have something tragic, terrible happen of no fault of their own. Product liability, intentional tort, someone assaults you, or God forbid, a sexual assault. And everybody wants to be compensated and made whole as much as possible. But at the same time, there's an imbalance, as has been discussed, that does need to be addressed. And this bill is a bill that addresses the concerns that have been raised regarding what is causing that imbalance.
And you alluded to that just a little bit. And we talked about Senator Dean Zaffirini brought up the tie to Medicare and at 300%. You and Senator Paxton talked about that as well. You and I talked about, and you're a doctor, I deal with Health and Human Services and the insurance side of this through the committee. There were some acts going on where injured people would be sent to doctors, and those costs were greatly inflated. Is that correct?
That is. A big problem, again, is the paid or incurred aspect, and the incurred aspect of how medical claims are handled in personal injury lawsuits allows for a system that has a symbiotic relationship between a provider and a law firm.
Right.
And the provider is incentivized to over-diagnose, over-prescribe, over-treat, and overbill, sometimes at rates that are 3,000, 5,000, 8,000% of Medicare.
Steered to that doctor.
Steered to that doctor. After that claimant, that injured individual, if there's a car wreck on I-35 right now, within minutes, there are these individuals that engender or go to that and pass out cards. They're essentially barratry. They're not the actual attorneys. They're finders of cases.
If
So
they were
there's
attorneys,
steerage.
that'd be against the law, right? And so
Yes, if it was actual attorney.
right.
But going back to the incurred medical bills, that's at the nexus and the root of why, one of the reasons is because the ever inflated medical bills figure into the economic portions. But if you can go before a jury and say, well, I had $500,000 worth of medical bills, you can sway individuals saying, well, you must be really hurt with that broken ankle, which, most of the time is, $6,000 or $8,000 type of situation. If it's $400,000, it must be really, really bad, and therefore you have permanent life impairment, and therefore your non-economic damages should be totaled and awarded very vigorously. And a personal injury attorney will point to the dollar amounts of medical costs that have been paid thus far or incurred as justification for the awarding of a fairly lucrative or very robust award during the deliberation of that by the jury.
And so in our office, and I want to say to Senator Hagenbu, some of the calls that we get, I would say very consistent 3 things right now: property taxes, 2, property and casualty, and 3, cost of healthcare premiums, cost of healthcare in general. And all of those misappropriated or inflated cases lead to higher costs for everyone. Is that correct? Absolutely.
There's obviously an incentive to overdiagnose and overbill at times, just in private practice. If you're working, and actually that pertains not just to healthcare. The number of lawsuits is directly proportional to the number of lawyers in a geographic region. They got to work, right? And that is unfortunate, but that is the system and the world we live in. You're not going to twiddle your fingers, and if you're a professional, you're going to find work. And I don't blame people for that in the sense of it being necessary, but there is an abuse of the system currently when it comes to personal injury cases that allows for a system that has manifests itself in the awarding of very large verdicts, and the frequency of those cases also increasing.
Well, I just learned that BlackRock was investing in this, so we should all stand up and take notice. I want to clarify some misconceptions out there, or you can confirm. Does this bill have anything to do with China?
This bill has absolutely nothing to do with China. This has every cause of action is still a cause of action. This changes nothing regarding the causes of action. I'm not for sure what the angle is in China. I know for those listening.
Let me read you a line.
These are attack
Communist
ads.
China will soon have the green light to poison and maim Texans like you.
It's ludicrous and completely false.
The only way standing in their way is a few conservatives in the Texas legislature. So this bill has nothing to do with China poisoning and maiming our children. Is that correct?
That is correct.
If you're harmed by a Chinese company, good luck on getting your medical bills paid. Does this bill in any way protect China?
Absolutely
or a communist country?
Absolutely not.
A communist company?
No.
And then finally, I want to ask this question. If this bill were passed, the bill would limit or prevent children who were harmed by radical doctors and transgender medicine from holding them accountable. True or false?
False.
Thank you, Senator. What I find, we can all argue the points of a bill, pro and con. We can be for a bill, we can be against a bill. But do you think it is appropriate that text messages and commercials are being sent from Virginia to Texas? Right? Do Texans appreciate Virginians telling us lies?
They don't, and I think our fellow citizens recognize that and act accordingly.
Thank you. So your bill strikes a balance between runaway cases that now BlackRock is investing in because it's so lucrative versus people that are truly harmed, who need their medical bills paid for, their pain and suffering, if they were in ways maimed for life, that you strike that balance and make sure that we take care of them.
That is correct.
Thank you, Senator.
Thank you.
Senator Gutierrez, for what purpose?
Will the gentleman yield for a few questions?
Senator Schwartner, do you yield?
I yield.
Thank you, Senator Schwartner. I had a whole bunch of questions, but Senator Judith Zaffirini asked a lot of them. And so I'm going to add a couple of other initials to her name. We're going to call her JD because she asked a lot of great questions. I didn't know she went on to law school. She's brilliant. I have some concerns about a couple things, but like I said, I think Senator Zaffirini did such a good job that she answered some of them. But then you brought up some things that do concern me. Medicare rates, you cap them at 300%, correct?
Medicare rates, the threshold for which they are admissible is up to 300% in the bill as adjusted by the inflation rate as measured by CPI, based on the Medicare rates as of May 1st, 2025.
And yet doctors come into our building for other reasons, always complaining about Medicaid and Medicare rates, don't they? Being too low.
One more time, Senator.
Doctors come into this building session after session and they complain that Medicaid and Medicare reimbursement rates are too low.
They come in and complain about Medicaid rates. Medicare rates are not set by the state of Texas.
That's right. Are they too low? You're a physician.
Medicaid rates are too low for certain types of services, and actually at times can be too high, in my opinion, for certain other types of services. Medicare rates are the exact same. They overpay for some services and drastically underpay for types of services.
Underpay for some. Okay. I don't know the answer to this because I'm not a physician like you, but I'd bet that you might. Is it possible for someone to be injured in such a way that future medical services for that injury are so novel or rare that they would not be included in the Medicare fee schedule? And that's an honest question. I don't know that answer.
There are new services, new procedures that are invented. So that is a possibility. Medical miracles can happen, advances in technology. I would submit that's true.
Well, if it's not on the Medicare fee schedule, what happens next in this bill?
If it's not in the Medicare fee schedule, it's not admissible as a compensatory amount. But of course, that is at the time of the actual injury. And at the time of the actual injury, there are economic and non-economic damages that are awarded by a jury, and the jury has to take into calculation future economic damages and potentials, and that consideration that you're bringing up would be in that aspect of the award.
So if there was some science that was in the works, research and development, and so there is no way to compensate for someone for something that might be able to solve their issue into the future, even if it's being researched at the time.
Like take a case, like if you're paralyzed, for instance, by an injury, and there's the potential for curing paralysis by some sort of intervention into the future. Does the jury have the ability to weigh that type of concern or theory or contemplative aspect into their economic award? I think they do.
Do they? I mean, there is a vehicle in here, an exception, an exclusion that allows them to go outside of the $300 Medicare limit?
Economic awards are both present and future, as well as past, present, and future. Actual costs are always admissible, obviously, but into the future, you have to make some extrapolation of things that you can do for that patient actually, and things that could be done for that patient if advances in technology were to allow it. And so that has to be calculated some way.
And I think that that's my point, and I think you're getting there, right? And you actually brought up a great point. When someone is paralyzed, the advances are so fast and furious in this space, for lack of a better term. We are seeing paralyzed people be mobile through robotics and through so many other things. And yet, because of that technology, you're saying that future damages to these folks can only be at 300%.
Well, those
Medicare.
type of technologies not part of, they're not medical costs. They're aids and other things that are figured into the economic aspect of the award.
Well, I guess that's my question. We're talking about future medical expenses, correct?
Yes, which is obviously a determination made by the finders of fact and the jury, the deliberative jury, in rewarding the economic side of compensatory damages, yes.
So the trucking company is liable for the driver is negligent, maims the car next to him or her, and this person is now paralyzed, and they're in the trial, and they go through it all under this new protocol, and that person is paralyzed and can't move very few limbs. And so they are capped at 300% for future medical expenses of Medicare cost in your bill, correct?
Again, Senator, for the adjudication of compensatory damages, you have the economic and non-economic. When it comes to the economic and their actual health care costs, not types of mobility aids or home additions or things that would be supportive, those also are a different category that the jury has full right to look at. But regarding the amount of past, it would be up to 300%. And then also future amounts is always, they always argue over future amounts about what is going to happen in the future regarding the medical advancement and care and the potential need of that injured individual that has been tragically and terribly injured, and whether or not there's going to be certain advances like you are describing that would allow for that person to become more whole.
But either way, the economic and the non-economic are capped at $300,000.
The future amount is still easily argued by a very capable attorney like yourself in front of a jury of 12.
Yeah. But I'm capped.
There's no cap on when arguing future.
You said there was no limits. There is a cap here.
On the health care incurred costs that are admissible into trial or the known health care amounts into the future. When it comes to other things that you are prescribing, that is not a health care, when you're talking about AIDS, et cetera, or potential advancements that are actually not even in existence, that is not actually a health care
I'm really not talking about AIDS. I'm talking about a paralyzed person that is in a chair and now with the advancement of science can now walk with robotics. And where that didn't happen 5 years ago, didn't happen 10 years ago, didn't happen 15 years ago or 20 years ago. And you yourself, as a physician, you've seen this happen. We have a center in San Antonio called the Center for the Intrepid, where warriors that have gone to different parts in war across the world are amputees. And the cost of that prosthetic, if you will, is massive. But we're limiting the economic and the non-economic at 300% of Medicare.
Again, that's a medical device, Senator, and certainly that would be argued by a capable attorney in front of that jury when it comes to the awarding of the economic portion of their compensation.
But I don't know if the medical advice exists today. It might exist tomorrow or a year from now or 2 years from now.
I would hope you would argue that just as you are arguing that with me now in front of that jury.
Well, let's change the subject a little bit because we heard a lot about trucking companies. And listen, I just had a conversation earlier with Senator Hagenbu. I mean, I do a little construction myself. I don't know if you know this, I actually own a funeral home.
You what? I'm sorry?
I own a funeral home.
You own a funeral home?
Yeah. Not a lot of people know that.
I was not advised.
Got sued the other day by some lawyers. I had to call them up and said, hey, what's going on here? And we squared it away. It wasn't about us. They just want us to preserve a body and so on and so forth. And it was interesting to me. So my point is I'm very sensitive to what Senator Hagenbuch's talking about. But there's also insurance greed, right? When the insurance company says, oh, it's these lawsuits, they're killing us. There's also insurance greed, right? Insurance companies make how much on their costs and their expenses? 30% increase on their margins?
Senator, I think all for-profit companies have a capitalistic profit motive, yes.
Doctors are greedy?
Doctors can be greedy, yes.
You said lawyers are greedy?
Lawyers can be greedy.
You and I, present company excluded.
Of course, yes.
Yeah. I have a bunch of poor clients in my law practice, a bunch of poor migrants. You stated in your testimony that the cost of health care, I think you, in your colloquy with Senator Kolkhorst, that these inflated costs were the result of these types of lawsuits. I would beg to differ and suggest to you that insurance CEOs are making money in the millions. The State Farm CEO made $24 million last year. Does that surprise you?
I'm not advised of what that CEO made. That sounds like a significant amount of compensation.
Yeah. I would suggest that Senator Hagenbuch and many others, and then a lot of people in this building, have a serious discussion about insurance company greed.
That's a different bill, Senator, and I agree with you that there needs to be better regulation of insurance companies. I have filed legislation reforming certain aspects of TDI as well as putting in various parameters of insurance.
I'm sorry, I didn't mean to speak over you.
No, please, go ahead.
You're not trying to take people's access to the courthouse away, right?
Absolutely not. There's no cause of action that's affected by this piece of legislation. This piece of legislation maintains and I think enhances a just, transparent, efficient, and fair compensation structure for those that have been injured by negligent torts, by intentional torts, as well as by defective product torts.
Right. You mentioned the word barratry earlier. There's nothing in this bill that's about barratry, right?
There is an aspect in the bill regarding the reporting of individuals that have affiliations with law firms and report types of cases to those law firms, yes.
Tell me about kickback arrangements. That was your term that you used earlier.
Yes.
What are you talking about?
Kickback arrangements of...
Who's getting a kickback? The doctors?
Doctors can, but also those that are out there finding cases for attorneys.
Okay, and the reason I mention this is because you said it. You said kickback arrangements, and I was concerned about what you were talking about, but it led me to one of the aspects of your bill. Mm-hmm. Your bill says that plaintiffs' attorneys have to disclose their relationship and referrals to a doctor, correct?
Can you please point to the exact page so I can follow along with you?
I knew you were going to ask me that. You know, Senator, I apologize. I don't have a page number on my notes here, but I know it's in there. You mentioned it earlier in line with someone else's questions.
The portion that regarding matters admissible into evidence?
Yeah, I think it was that you suggested that because of these relationships.
Yes, if a person making a referral was an injured individual's attorney, an anonymized list of persons referred.
Is it okay, that plaintiff attorneys have to disclose their relationship and referrals to a doctor? In other words, what does that mean in the context of your bill? Because it's in there.
There are significant affiliated and associated arrangements between plaintiff attorneys and networks of providers, not just doctors. We're talking chiropractors, therapists, surgery centers, that have a relationship that they take a claimant or a injured individual, and in an attempt to make them whole, there's also a secondary incentive to overdiagnose, overtreat, overbill for those medical services that lead to inflated incurred charges that are seen, that have a secondary effect on the economic and non-economic aspects of the award during a personal injury case.
I don't know if that's happening or not. I'm going to assume for purposes of this argument that you're right, that this has happened before. My question is, does this have to be disclosed, this relationship, to the jury?
I think the finders of fact should have all sorts of information that is pertinent when it comes to affiliations between a provider group / network and that plaintiff attorney or the firm for that plaintiff attorney that is working. So yes, I think it is relevant information, and that's why it's in the bill.
That's my point. I know that you studied all this. Did you study the rules of evidence?
I'm not an attorney. I understand there are ways in which judges look at discovery information and decide what is allowable and admissible. I will certainly be instructed by you if you would like to go down that road.
No, and I'm not trying to be snarky in any way. I'm just saying the rules of evidence call for evidence that is relevant in a case. And it's, hell, I have to read it to you. It's evidence has a tendency to prove or disprove a matter of fact. Yes. On that particular case. There's also, at times, another definition. Does the probative value outweigh the prejudicial effect? My point is, this relationship between doctors and lawyers, I don't care. What this referral that I have to disclose this to a jury, does it have a tendency to taint the jury against the plaintiff? I'm asking.
Absolutely not. I think there are matters that should be admissible into evidence. There are certain courts that do not allow that to happen, which prejudice against the defendant in a case like this. And so I think it is reasonable to put uniform protocols and standards in place that allow for evidence that should be statutorily admissible, but maintain judicial discretion and the rules of evidence otherwise.
Does your bill allow for a judge to have that kind of discretion and not allow for this relationship between the doctors and the lawyers to be brought out, or is it mandatory in the bill?
The matters admissible into evidence is very clearly delineated in the bill and includes the documents or information provided by the claimant under section 41.105, referrals, and then treatment guidelines and drug formularies approved by the Workers' Compensation Division regarding the necessity of health care services provided. Otherwise, part of my amendment will maintain the rules of evidence for other aspects.
This discussion about this particular point is really important to me, and it wasn't in my notes. It's something that I heard you say, and then I read something here. It has nothing to do with causation. In other words, the fact that you have to tell the jury has to hear the relationship between the doctor and the lawyer, has nothing to do with causation or any of the elements of negligence. I think we can agree on that, correct?
One more time, Senator.
The fact that the plaintiff's lawyer would have to disclose how many times they've used this doctor or chiropractor or whatever has nothing to do with the ultimate facts of the case, whether his trucking company or any other trucking company was responsible and proximately caused the injury to the plaintiff, correct?
It's evidence that should be presented to the jury.
Why?
It is because it is relevant when it comes to the awarding and the understanding of the non-economic damages and the medical bills associated with it.
But if the bill passes, you already cap your economic and non-economic damages at 300%. And so why is this highly prejudicial thing? Because all it's doing, Senator, Doctor, is it's intended to tarnish that lawyer, to tarnish that doctor, and in effect, hurt that plaintiff that is truly hurt, that truly was the victim of a trucking company's negligence.
It is.
And all you've done, let me finish, sir, by adding this piece is make it highly prejudicial and you've stained it in such a way that by law, by the rules of evidence, the probative value of having that piece of information in there is not outweighed by its prejudicial effect. In other words, highly prejudicial. Highly prejudicial to the minds of a jury. Because they're going to hear what you guys said in here. Oh, it's the lawyers that are on their planes on TV. Vast majority of these cases out there are not the lawyers on the planes on TV. And by the way, so what if they are? But the introduction of this clause has nothing to do with a negligence case one way or another. It is solely intended to prejudice a jury against that lawyer and against that doctor, and to create the notion that there is some kind of scam in play.
Senator, that provision of the bill is only applicable if the attorney refers the claimant to those providers. And I think that is extremely relevant information for the jury to know and to weigh that there is an affiliated association between that plaintiff attorneys and this network of providers that are affecting the medical care of that patient directed by that plaintiff attorney, essentially.
You know, Senator, Doctor, I think it is, in my opinion, highly prejudicial. It's your bill. I will have an amendment about this. I don't think we need to say any more. We'll let the body decide whether they want their constituents to have access to the courthouse or not, because I'm against the bill, to be quite honest. But the most disturbing part is that right there, is that you tarnish the profession that I'm in. And even the profession that you're in, and you make an assumption that all doctors and lawyers are a bunch of greedy bastards, and that's just not the case.
Senator Johnson, for what purpose?
A couple questions of the author.
Senator Schwertner, do you yield?
I yield.
Thank you, Senator Schwertner. I'll probably have some more extensive comments when we get around to amendment. But for now, just comment on some of the discussion or asking questions about some of the discussion. Much has been made about insurance rates, which certainly are high. And I know you've done work at trying to rein in insurance companies and possible abuses or just market distortions there, and we appreciate it. Do you feel confident, not stop short of promise, but do you feel confident that passage of this bill is going to lower auto insurance rates or health insurance rates? Was there any testimony to that effect? I'm sorry, I'm done now.
I think this bill is more than just about economics and the financial effects that are being felt by Texas families and businesses. This is about a fairness and transparency and a system that allows for an efficient but just and fair and reasonable method to compensate those that have had wrong done to them. Insurance rates or insurance goes up for a whole host of factors, as you know, whether it's supply chain issues, inflation, reinsurance, but also part of rising insurance rates is in liability. When you buy car insurance, you're buying your first part and mandatory part is liability insurance. And if there are more, the frequency of lawsuits because of a system that does not properly adjudicate personal injury claims fairly and efficiently is not out of control, but robust and growing, the problems associated with it, then certainly you can have rising insurance rates, and it is a factor.
I'm going to predict that they don't, but if the bill passes, we'll have an empirical discussion about
This was a discussion not dissimilar to what happened after the passage of HB4 regarding the capping of insurance or of non-economic damages for healthcare providers. And at least from my personal experience, I know healthcare, medical liability, medical malpractice rates went down fairly substantially at that point. This bill doesn't do that, though. This doesn't cap the award.
Understood, and you're probably aware of the argument that the entire medical malpractice insurance rates phenomena was tainted by an artificial run-up in insurance rates in anticipation of the tort reform that was to follow.
I'm aware of the arguments counter to what I said, but
We've burned in so
believe-
much time here today, I guess we probably shouldn't burn on that one.
Yeah,
if
yeah, we don't
can.
need to, unless
We'll
you'd like
have a
to.
longer discussion when my amendment comes up, which hopefully will be 5 or 6 minutes from now. Probably not, though.
Senator Card, for what purpose?
To ask questions of the author and get to those amendments as soon
Senator
as possible.
Schwartner, do you yield?
I yield. Senator?
Senator, thank you so much for taking my questions. And I believe you had mentioned that you do take Medicaid and Medicare patients, correct?
I do.
You also take workers' comp covered patients.
I do. I've been a treating doctor and a designated doctor, actually, in workers' comp, which is fairly rare.
Thank you so much for that. I'm sure you're aware of the Texas Department of Insurance study with regard to the numbers of doctors across the state who actually will take a workers' comp.
Yes. I know it is less than I would like and less than the people that have been injured in workers' comp cases. Those rates are different than the rates that are proposed in this bill regarding what is admissible as evidence of medical loss. And so that's why this bill is different than what was initially proposed in the initial layout of 150% of workers' comp. This is 300% of 2025, May 1st, 2025 Medicare fee schedule adjusted by inflation.
And thank you so much for pointing that out. And you said that you are very proud that you are one of the designated workers' comp physicians, correct?
Yes, I'm not for sure if I am anymore, to be quite frank, but I had been in the past for some time. I'm a treating doctor for sure.
I deeply, deeply appreciate that. So in line with Senator Gutierrez's questions, as a designated doctor, of course, employers have a smaller pool to which they can refer their employees for injuries, correct?
Yes, are you referring regarding a workers' compensation injury, or are you referring just about a health care plan that an employer has for their employees?
Workers' compensation injury in the scope of their
the largest
employment.
carrier is TML in the state of Texas. It has like 60% of the business. They have a fairly robust, I guess the most robust network, but each employer decides which workers' comp insurance carrier to subscribe to pay premiums to. So it depends upon the carrier.
So we had talked a little earlier, and I do have an amendment, so I wanted to ask you some questions specific to that. We've talked about in order to be recoverable, medical bills must be both reasonable and necessary. The reasonable portion is the 300% of the current Medicaid rate, correct?
Yes.
And then the necessary portion, and this is further along in your bill, so for anybody who wanted to take a look, on page 8, and it goes somewhat to what Senator Gutierrez was asking. On page 8, section 41.107, matters admissible into evidence.
Yes, I'm with you.
You and I had a conversation earlier about the workers' compensation treatment guidelines being statutorily admissible. So your bill would make them statutorily admissible by either party, correct?
That is correct. That's in the matters admissible into evidence, section 41.107 of the bill, regarding the necessity of healthcare services provided to the injured individual.
And I think you and I agree that we certainly wouldn't want a plaintiff to be able to recover for unnecessary medical expenses. I mean, that I think goes without saying, but I'll go ahead and say it.
Services should be reasonable and necessary.
And we also agree that treatment, the necessity of the treatment should be determined by judge or jury. And if judge or jury do not find them necessary, that should not be recoverable in economic damages.
The jury has ultimate, the arbitrator of culpability as well as award. So yes, I would agree with your statement.
So I apologize for the legal aspects of these questions, but with regard to creating a statutory required acceptance of workers' comp guidelines into evidence, a statutorily required admission takes away the judicial discretion of determining the probative versus prejudicial value of that evidence, correct?
This section would be statutorily required to be submitted into evidence, correct? It does not remove the deliberative nature of the jury when deciding whether or not it is a necessary healthcare services that should be compensated for. It just allows for further evidence and information to be given to the jury in a mandatory fashion, yes.
So the judge has no discretion with regard to admitting this piece of evidence and also no discretion with regard to limiting the utilization of this evidence, correct?
The evidence as written in the bill that would be necessary or be required to be presented would be treatment guidelines and drug formularies approved by the Workers' Compensation Division of Texas relating to the necessity of healthcare services provided to the injured individual. It is further information for a contemplative jury to have when deciding regarding the awarding of the case.
And I think that you and I agree that while this piece of evidence, workers' compensation guidelines, must be admitted statutorily, it doesn't prevent other information from being admitted that could rebut it.
No, not at all. There's other, and that would be up to the rules of evidence and judge discretion.
So since this is statutorily admitted, and there is no judicial discretion for limiting its application, would you agree that this statutorily required admission creates a presumption, albeit rebuttable, of what is necessary treatment?
I think it allows further evidence to be entered that allows the jury to make a more informed decision.
What is the purpose of workers' comp?
To restore a injured worker to as high a function as possible, to make them whole.
So the workers' compensation guidelines aren't written with consideration of child victims of an injury, correct?
No, those are usually adults that are working, not children. We have child labor laws in Texas.
And workers' compensation guidelines also aren't written contemplating the elderly injured. Would you agree?
There are elderly people that work. I think they are more applicable to individuals that are adults. If it's not applicable, it's not applicable.
And also the workers' compensation guidelines are written with the presumption that there is an existing employer-employee relationship, and there is essentially a duty of care between these two parties.
Yes, that is the basis of the workers' compensation system. And on the flip side, there's liability aspects that are recognized as regarding the ability to sue your employer if you have workers' comp.
And because in the state of Texas, workers' compensation is a voluntary program, there is at least some incentive to limit the liability of the employer in order to attract them into the workers' compensation program. Isn't there?
Senator, can you re-explain that? I'm sorry.
Sure. The Texas Workers' Compensation Program is a voluntary program, unlike, I think, every other state in the nation. And so in exchange for employers participating in workers' comp in Texas, they are shielded from personal injury liability of their employees. So that's the get from their voluntary participation.
That's my understanding, yes.
So let me give you a hypothetical. Trucker, works for a trucking company. He's injured in a car wreck. It's in the course and scope of his employment. He goes to a doctor that's under the workers' compensation insurance plan. The doctor says, we definitely need to get some tests. You could probably benefit from some PT, and we could do surgery, but really we need to hold off and do the PT first, and the surgery may never be required. So clearly the tests and the PT are necessary. The surgery may be necessary in the future. Is that a realistic scenario?
Yes, sounds realistic, yes.
So let's change up the hypothetical, and the trucker is working for the trucking company, but is involved in a collision that injures a child in another car. Do you think that those same workers' compensation guidelines should be applicable and are even relevant to a child who's injured in the collision?
Senator, that's a negligent situation, tragic and terrible. Regarding workers' compensation, it really wouldn't be applicable in a child, as you mentioned earlier, because they are not working age.
I completely agree. And yet, your bill says that in a tort, the judge must admit the workers' compensation guidelines as proof of necessary medical treatment for that child who is injured.
That's not how, that's not correct, Senator. It is a piece of information that has to be given. Whether or not it's applicable is dependent upon the situation and obviously the collective wisdom of the jury.
But you don't dispute that under your bill, the judge must allow in the workers' compensation guidelines, even though we both agree that they're not relevant and have more prejudicial than probative value in regard to a child victim.
They are a piece of information that would not be consistent with adjudicating that. If I was a jurist, I'd say this doesn't make any sense. I'm not going to pay attention to it.
Thank you so much for answering my questions, and I will have an amendment in that regard.
Senator Schwerter moves suspension of the regular order of business on committee substitute for Senate Bill 30. There is objection. The Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Cook.
20 ayes, 11 nays. Rules are suspended. Chair lays out on second reading committee substitute for Senate Bill 30. The Secretary will read the caption.
Committee substitute, Senate Bill 30, relating to recovery of damages in civil actions.
Following amendment, Secretary will read the amendment.
Floor amendment number 1 by Schwertner.
Senator Schwertner, you recognized.
Thank you, Mr. President. Members, I'll go slow here, but this is an amendment that has been already submitted to all the offices early this morning. The first section clarifies the non-economic damages definition of the portion that consists of mental and emotional pain and anguish. And then the second section there, starting at line 5, clarifies the definition of physical pain and suffering and the non-economic damages definition of physical pain and suffering. Then starting on line 15 through line 21, it adds licensed professional counselor and psychologist to the list of providers. Not exclusive list, it's an inclusive list. And then line 22 on allows for the Texas rules of evidence in all sections other than section 41.107 regarding matters admissible into court. With that, Mr. President, I'll be happy to answer your questions or move adoption of floor amendment number 1.
Senator Betancourt, what purpose?
Ask questions of the author of the amendment.
You yield.
I yield.
Senator Schwartner, I want to first off say that this amendment is, I think, an exceptional work that you've done with the stakeholders and many of us here on the floor of the Senate. I want to point out in section 1, because I think, as you know, we took some very difficult testimony, okay, about the survivors of sexual assault and the deprivations against children that have occurred. And I want to point out what I think are tremendous changes that support the survivors of sexual assault in this bill. First off, on the first page, you strike daily routine, you substitute life, because that's a problem when we look at sexual assault, because it affects people really for their life. And I want to read just into the record something I think is a very important statement that you put into this, into the amendment, which is line 13. In cases of sexual assault or abuse, is corroborated by medical evidence or a prior consistent statement. You want to say how important that is for survivors of sexual assault?
I think it articulates very clearly that physical pain and suffering by individuals that have been sexually assaulted or abused is allowed by corroboration of the medical evidence or prior consistent statement, and make sure that those people are recognized when it comes to the definitions of non-economic damages, both the physical pain and suffering as well as mental and emotional pain and anguish.
Right, because the testimony we took was horrifying, and you know, the sexual assault case of the young gentleman that suffered just horrific depredations by family members and his younger brothers was so stunning that I think it galvanized everyone that on this bill, especially all the committee members, how important it is to make sure that that survivors of sexual assault and child abuse are given given the due they need to be able to recover the damages that they've incurred, and the difficult recovery that they have, and the long-term expenses that they have. So I just want to commend you for writing this amendment so strongly for them, because you know, having you know, words like life and you know, and as in cases of sexual assault or abuse, you know, having a prior consistent statement are so important to their cases, and more importantly to their health and well-being long term.